Awesome. Well, Joel, thank you for joining us today. Joel Lehrer, you're an intellectual property law attorney at Goodwin here in Boston, and we're really appreciative of you taking the time to chat with us today. We specifically want to talk a little bit about AI because AI and software generally has kind of existed in a weird way with patents. It doesn't neatly fit in the system the way other inventions do. Um, and so, with that, let's dive into the conversation. But before we get into the specific questions, Joel, if you could just give us like a 60-second overview of like what is intellectual property? Why is this conversation even important?
Sure. So intellectual property is really kind of a bucket of various different types of rights that people may or may not be familiar with. Copyrights, trademarks, trade secrets, patents kind of all fall under IP rights. Um, so when we talk about software and computer technology, it can kind of fall into a couple different buckets, right? You can have source code, for example, that would be considered a trade secret. That's one type of intellectual property. As most people know, when you write software, the code you write is given copyright rights. That's why you see people licensing software the way they would license a book or a manuscript or a song. And then in some instances, you can get patent protection for the functionality that software implements, right? So if I invent some sort of new data compression algorithm that allows me to put, a 2-hour high-def movie on a thumb drive, that might also be given patent protection. Now, it's not patent protection over the specific source code, but more generally, the functionality that source code allows you to do, which is good because what that does is that means that anyone that might come up with that process, regardless of what software they write, could potentially be infringing your patent. So it's a broader right, but it's harder to get and harder to enforce.
And so now I'm going to turn it over to Jasmine. Jasmine is one of HLEP's ambitious 1Ls. We start early, putting responsibility in the hands of junior law students. And with that, Jasmine, why don't you take it away?
Of course. So, Joel, again, thank you so much for being here to chat with me today. I just had a couple questions for you about
Sure.
IP and patents. So, getting started, I know the USPTO has some recent guidance on AI related patents. From the startup perspective, can you tell me a couple of elements that startups should focus on when they want to strengthen their applications?
Sure. So one of the things that I tell startup clients that I work with is the patent office has gotten much, much stricter around granting patents on software-enabled methodology. And the use of AI is no different. And what I mean by that is that in the past, one might have thought that simply applying artificial intelligence or machine learning technologies to a known problem might in and of itself be enough for patent protection. And it's really not, right? There needs to be kind of a little bit more technical contribution by the inventor to rather than just simply applying known AI technologies, machine learning techniques, data analytics to a known problem. So what I tell startups is, first and foremost, really think about the market you're in. What niche market are you operating in? And what unique challenges are you seeing that are different than in other potential markets? And then what do you have to do? What changes do you have to make? Or what very specific features do you have to add to the AI or ML technologies that you're implementing to make it work in your field? For example, do you need to enhance the data privacy protections for data that's being used to create machine learning models because you're operating in a healthcare type situation, right? Where you're looking at protected health information and need to ensure that that information is not released or used in a way that violates various statutes like HIPAA. So that's one example, I think.
So let's say I'm a startup and I applied for patent protection, but I got rejected.
Yeah.
What are my options? What types of things can I do?
Yeah. So that's a very broad question, and it's not unique to AI for sure, right? Because I think something like 98% of the patents that get filed get initially rejected by the patent office for being too broad or not directed to patentable subject matter. So, as folks may or may not know, when a patent application is drafted, there are a couple different sections. The main body of the patent is called the specification. That is fixed in stone. Once you file that application, the specification cannot change. So you are stuck with whatever in that application in terms of your disclosure. Now, the claims at the end of the application are really the kind of legal metes and bounds of what you're claiming. That's what you negotiate with the patent office over, right? So I may start with a very broad claim, and the patent office may reject that claim and say, look, that's too broad, and I narrow it during the prosecution process. That's the kind of negotiation back and forth. So what I tell startups is you really need to make sure that the specification has in it all the details you might need to narrow your claims during prosecution. And in fact, with a lot of startups, I kind of take kind of a contrarian approach to prosecution, which is to start narrow, right? Because as a startup, if I tell you, oh, I might be able to get you a patent in 4 or 5 years, that might not be helpful. But if I say, look, let's start with a very narrow claim that is exactly directed at what you do and the particular feature that you think differentiates you in the market, and I can get you that patent in maybe 8 months, that's a huge benefit.
And then my last question for you is kind of future looking. So I imagine AI guidance is going to continue to shift and grow as more
Absolutely.
technology is developed and as the government has a better understanding of what's happening. So again, the startup perspective, what should startups be doing now in order to prepare for these changes? Because I imagine like the patent guidance will also change as well.
Right. So first and foremost, I would say, engage with competent patent counsel because it's our job to stay on top of these things and to review the guidance that comes out from the USPTO. There was guidance that came out over the summer that had some very specific examples that gave good examples of things that are patentable subject matter and some that aren't. That's number one. Number two, take advantage of things like provisional patent applications and non-publication requests at the PTO, because what this does is this gives you the opportunity to file applications and delay decisions that might include additional costs or whether or not to actually let some subject matter become public. I do often counsel clients who come to me with what I would call questionable patentable subject matter, right? Well, and say to them, look, things could change, as you mentioned, right? The guidance could change, the laws could change. So if it's something that I think is truly valuable to that company, I would say, let's get something on file. Let's file a provisional application. Now, let's not spend a ton of money on it, but at least make sure that we get some coverage. And then later down the road, as maybe things evolve, we can decide whether or not to pursue that application as a full application, whether or not to invest the money in the process.
I've got one final question,
Sure.
just to tie this out to the larger conversation around business concerns. And that's one of the things you mentioned was saying, okay, well, we're weighing the trade-offs between it being narrow or broad and the timeline, or not spending too much money on this because it may not be worth it at this stage in the business or in the product. How do you think about those trade-offs, and how have you developed an understanding of those trade-offs over your career?
Yeah, I think it comes with just working with a lot of startups, right? And understanding that the goal of a company is not usually to get patents. The goal of a company is to create, market, sell a successful product or service. And if there can be patent protection around that that helps them leverage their, their products better, then that's great. So what I often do is, I'll have a client come to me with 3 or 4 different ideas, and we prioritize those, and we look at them in the light of, well, how much time, effort, and money do we really want to spend on this process? And if I told you for, X number of dollars, we could get you a patent on this, is that worth it? Or if I said, look, none of this is going to result in any patent, but is it worthwhile to spend X amount of money to have a disclosure schedule with 3 pending patents and to be able to say that your technology is patent pending for the next 3 years while you're out raising money? Is that worth it? Even though we know that in the end we might not get patent protection, there might be some value just in the fact of being able to stay patent pending and having patent applications on file for some number of years to attract investors or to be a better M&A target in an exit process.
Well, that makes total sense. And Joel, again, thank you so, so much. I felt like all of this advice is going to be super helpful to the startups that we're working with.
Yeah, happy to do it.